Brian has been in this community before I was in the community. I met him, and for the first time I saw him speaking at the first conference I ever went to at ISNAF. He's an attorney. He works in the United States as a strategist. He's a member of multiple professional organizations, PASG being one of them. He's been on the advisory board of ISNAF since we've had an advisory board. And he's does all kinds of advocacy work nationally and internationally. He's an international speaker and an author of the book called High Conflict Custody Battle. And I could go on and on about Brian because he's just everywhere. I don't even know where he finds the time. But I worked with him on multiple cases for parents, and he works as the strategist. I work as the coach. And we are starting to see some amazing new change in some of the results. So with that, Brian, the floor is yours.
Very much, and thanks for that intro and hosting me. And I always enjoy speaking for ISNAF and meeting people involved with it. Cindy herself, what a devotion to the cause and the many hours that she spends. We're thrilled to have her as part of our community. I'm going to speak about something today that had always intrigued me, but which I had occasion to look into in more detail over the course of the last couple of years, where I was managing a couple of cases with a very broad spectrum of false allegations of sexual abuse. And these are very, very difficult cases. But like all false allegations, and most high conflict family law is rife with them, alienation cases are particularly plagued by them because the favored parent knows that the children's behavior is quite extreme, and simple parent-child disputes can't account for that extreme behavior. When we're diagnosing it, we refer to that as the disproportionality of the children's behavior. And the behavior never seems to resolve, the family never seems to heal. So there's some processes going on to keep the children in a state of anxiety, or a state of hatred, or a state of fear, that are founded on misconceptions, misattributions, misrepresentations, and outright fabrication. So if you're thinking about how you're going to deal with this over the course of a case, other than simple denials, there's a strategy to deal with false allegations, and I've spoken frequently about that, and I will take us through some of my cheat sheet for how to prove a negative, if you will. That's actually what we have to do, using a PowerPoint that I put together for the June PASG conference in Fort Collins, Colorado, that Cindy was a big participant in as well. But I want to start off with something I've been studying for several years, and that is the science of memory and how the law deals with the science of memory. Because far too often, we've all experienced it. The decision makers in the case say parent A is to blame and parent B is to blame, but gosh, we believe the children. And the children, of course, enmeshed and totally aligned with one parent. Doesn't seem right, particularly when part of our job is to put in collateral evidence and hard evidence and good forensic thinking to show that whatever the children are saying cannot possibly be true, or is grossly exaggerated, or should have healed long before. Normal parent-child dispute, not supposed to lead to a complete wipeout of the parent-child relationship. So there's something more insidious, something more powerful, something more enduring going on. And memory science would suggest what that likely is. I have a whole library here of books on memory science, and the research that I did for some of these recent cases was on the topic of how does the law deal with that? Does the law even know that that memory science exists? And are judges proceeding on the basis of fallacies, particularly given what has happened in the PA world of it being tremendously politicized instead of just rooted in evidence-based science? So one of the most common fallacies when you understand memory science is that the children are maintaining a good or reasonably normal relationship with the targeted parent year after year, even over the period of time that some of the earlier false allegations are arising, and then it all falls apart. And what are we anchoring on? We're anchoring on something new, hadn't been asserted as a problem before, certainly hadn't been asserted as something that was impairing the parent-child relationship. And when you get into what is this narrative, what is this allegation or assertion, you find that it relates to something that allegedly happened 3, 4, 5, 6 years ago. But yet, the parent-child relationship was much better then than it is today. So what's going on here? Is that even possible? Or is this just a new fiction? And the error in common thinking and understanding of memory is that, well, the children were traumatized or the other parent was traumatized. And so it's only coming out now years later because the particular allegation was just buried and out of sight, out of mind due to the alleged trauma. And I see that all the time. But it's not true according to the science. There are only the most rare and extreme circumstances where that sort of thing happens. What we deal with in these family law cases, if there's been no word about it for years, or if it was asserted in a much more minor fashion with a minor impact previously, and only later takes on iconic status, it's not true. It's just not how the mind works. And so part of the job now, therefore, when you're facing these sorts of situations, and the false allegation, we're talking about broad spectrum principles of memory science and the law of memory, if you will. Doesn't matter the nature or type of allegation, extreme yelling, extreme rigidity in parenting, physical abuse, emotional abuse, psychological abuse, sexual abuse. We're talking about is the allegation true? Is the allegation as impactful or as broad as the description that is now coming out many years later? And as I said before, we face that sort of conundrum in almost all alienation cases. So here's a nice piece of rhetoric from the movies. Cindy knows that I will often sprinkle rhetoric from the movies, and California, of course, being the worldwide home of movies. I always have to toss a couple in. I have a relative up from Oklahoma City, and last night we watched Inception, the Christopher Nolan film with Leonardo DiCaprio. It's an amazing film, very complex. You don't really start to get it till the second or third time you watch it. But right from the outset and it's all about thoughts and memory and that sort of thing. Right at the outset of the movie, you have an amazing piece of rhetoric that describes what we struggle with in these cases with false allegations. And so Leonardo DiCaprio's character says the following: an idea is like a virus, resilient, highly contagious. The smallest seed of an idea can grow. It can grow to define us or destroy us. Once an idea has taken hold of the brain, it's almost impossible to eradicate. And that phrase was at the heart of the story in the movie Inception, which, for those of you who haven't seen it, or those of you who want to see it again, it's currently streaming on Netflix and Amazon Prime and one or two of the other ones, and a highly entertaining, great music score as well by Hans Zimmer. And it's the same Christopher Nolan who did the Oppenheimer film that you're reading about in the papers today. So the quote from the movie about the resilience of an idea and how an idea can grow once it's implanted is a very apt description of what we have to deal with in these cases. Because there is a parent suggesting all kinds of negative things about the other parent, planting seeds, if you will, then fertilizing and watering that field, and sending the child messages that you're warmly received when you adopt those thoughts and ideas and views and impressions, and kind of exposing the child to something called misattunement, the cold shoulder, lack of interest, changing the subject, looking elsewhere, if the child says anything positive about their experience at the other house. So, since we face this on all these cases, all high conflict cases, including PA cases, it's important that we understand memory science, because it may help us in refuting the false allegations. And I'm going to give you guys a whole bunch of tips and hints here. But let me start first with what is the short executive summary of what we understand to be how memory works. And there's a thorough publication with an executive summary, or cheat sheet, if you will. So there it is, British Psychological Society Research Board Guidelines on Memory in the Law. And it's a publication of some 50 pages or so, so it gives you all the background. But let's go to that executive summary. So what these are, if you look at the intro here, they're guidelines, they're not absolute statements, but they're based on widely agreed and acknowledged scientific findings of how memory works. And I have a book rack filled with textbooks on memory science. And if anybody's interested in a more accessible book, I mean, this is a pretty good publication, but something written for a broader audience is called Memory Illusion by Dr. Julia Shaw from about 6 years ago, still very, very current. So what I'm showing now on this screen is the takeaway page. The key points that the British Psychological Society Research Board is saying judges can take these to the bank. This is accepted science. So if you think about the legal tests that courts in the United States and Canada apply before they admit expert evidence, experts should be speaking to settled science and not speculative science or science that is still in the course of trying to achieve a consensus. Well, since 2008, the British Psychological Society has been telling us that this is accepted science. And there are always specialized aspects of every single case. We can't just apply models, much as we find models useful when dealing with complex processes like parental alienation. But these we can accept as a given, and the recovered memory sort of thinking has been debunked. That is just not how the mind works. So if I was going to explain to people, and what I'll do is I'll stop sharing screen because it minimizes everything. In a nutshell, memory is exactly not like iTunes. So if you have a digital song, you can play that 1,000 times and it will reproduce perfectly, bit by bit, bit being the smallest piece of the data. It'll replay perfectly every time. And you save it, you shut your computer down, your computer crashes. That digital file will replay and replay perfectly every time. And its original recording will be exactly as it was originally recorded, subject to the compression algorithms they use. Memory is exactly not that. Memory is never a full and perfect picture with all the details in the first place. It's a record of an individual's experience of something, not the event or picture or happening or dialogue itself. When you remember, therefore, you're not recalling from long-term memory into short-term memory, bit by bit, that original recording. You're reconstructing in a predictive fashion what your mind holds as your prior experience, as opposed to the prior recording of your experience. So it's already colored by lots of other factors, assumptions, other events, when it's encoded, and then when you recover it, it's rebuilt. Memory is a reconstructive process. And in the course of reconstruction, it's influenced again by the environment in which you're remembering. So to translate it to what people experiencing PA are going to be seeing, child is only or the vast majority of the time living with one parent who's committing parental alienation behaviors. Child's living in an invalidating environment about the other home and the other extended family. And therefore, whatever the child remembers of that other life, that other home, is getting colored by the current environment. Whenever the child thinks about and misses the other parent, that's taking place in an environment where we don't think positive things about the other parent. And so that historical memory is continually being tainted. The other thing is, memories are always incomplete. Not every aspect of the prior experience is encoded. And that means the brain fills in the gaps when you attempt to recall the memory. And the brain fills in the gaps with more current information. If the current information is that the other parent is not safe, not available, not loving, not friendly, well, the gaps are going to be filled with aspects of that. And as a result of all of this, memory science, accepted memory science, tells us that recall is absolutely not a guarantee that a memory is accurate or even that it actually occurred. The content of memories, being a reconstructive process, is going to be affected by conscious and non-conscious processes. And as a result, people can have vivid memories of occurrences that never happened, or utterly distorted memories of what actually occurred, and they'll speak to it as if it was just yesterday with clear conviction. We see that, for example, where a child has been interviewed time and time again by therapists and custody evaluators and child protection authorities about whether their mother did something to them. Well, after the 10th such interview, any child is going to say, why is everybody so worried about mom? Mom must be dangerous. Or they're all asking me the same sorts of questions about a particular possible event. I guess the event happened. And then the child adopts it from the repetitive questioning. I had one case of false allegations. It wasn't sexual, it was physical and emotional, in Ottawa about 6-7 years ago. A lengthy trial, where at one point the local child protection authority in Canada, they're called Children's Aid Societies, refused to open an investigation for the latest allegation because they said, we're never going to get a clear picture from the kids. It's same old, so we're not going to do it. We've investigated and dismissed allegations against the father so many times. We simply will not get a clear picture from the kids, so we're not investigating this time, which was actually a very insightful view. But in the most recent trial I did, everybody, the judge, the children's lawyer, the lawyer for the father, that was me, the lawyer for the mother, all saw on the Zoom screen a confabulation, meaning the construction of something that never happened. We saw it happen live within 45 minutes, start to finish, in an adult. not even in a child. And there's a lot of science and judicial recognition that children are more susceptible to false allegations and manipulation and false memories than adults for various reasons. So here's the confabulation that happened right in the middle of trial evidence. The issue, simply stated, was whether there had been a transfer meeting between an incoming child protection worker and supervisor taking over a family that had a very lengthy file and the outgoing caseworker. Was there a meeting or not? That was the issue. And of course, when the caseworker, the outgoing caseworker, is still with the agency, it's standard practice, it makes sense, and it's in accordance with provincial guidelines for there to be a transfer meeting. In this case, the file was rather thick. For sure, you should have a transfer meeting. We knew because the incoming caseworker and the incoming supervisor had already testified, and we had already read the whole child protection file. We knew that there was no transfer meeting, and unfortunately, in part as a result of that, the incoming crew formed a false allegation themselves, ran to the police, got the father charged with just such a vast array of abuse, and took about a year or so to get all those charges, every last one, dropped unconditionally. But it totally destroyed this family system. So when we got to the third child protection worker who was testifying, which is the outgoing worker, start asking him questions and leading to the handover. And I asked him why there wasn't a transfer meeting. The incoming people it was like just a race to the police. They just formed their own view and they didn't really care about the truth. And he couldn't understand why there wasn't, told us that it was standard practice, told us that he had very good relations with the incoming worker and supervisor, and that there had been other files where he had done transfer meetings with them. Hadn't seen the file since he came off the file, doesn't really know what had happened since, but was puzzled, just it was very innocuous. And then as the cross-examination went on, because he had about a 1-year history with the family, he started to kind of stop here and there as if he was searching his mind. Maybe I'm wrong about that. Maybe there was a transfer meeting. And other than the fact that I had summons to me that had no involvement whatsoever with the family for about a year and a half, something like that. So, we could understand he's trying to recall, the other two were negligent, to say the least, and just seemed to want to engineer a result. This fellow was quite forthright, honest, just wanted to be helpful, wasn't trying to engineer any sort of result. And over the course of the questioning, you could see the gears turning. And at one point he said, it's possible that there might have been a transfer meeting. And then, the questioning went on. I was cross-examining him. The children's lawyer was asking him. The mother's lawyer was asking him questions. Then I got re-examination. By the end of that process, he had formed a memory over the course of about 45 minutes or so. He had formed the memory of the transfer conference. He was now certain that a transfer meeting for this family had happened, couldn't account for why there weren't notes in the file, because this is highly regulated. Child protection workers have to reduce to formal notes in the system that then doesn't even allow any changes to those notes to protect the integrity of the record because of the seriousness of their work. And he was certain, despite the fact that there was nothing in CPIN, that there had been a transfer meeting. So then I said, it's kind of interesting because we had the incoming caseworker and the incoming supervisor. We asked them, and they were trying to come up with excuses for why they deliberately didn't have a transfer meeting. And you're now telling us that you now have a vivid memory of it? Are you sure? And now I've told him that the other two people who allegedly were in the meeting had testified that there was no meeting. And even in the face of that assertion from me, he said, no, there was a meeting. So there you have it. It's an adult who was simply trying to do the right thing and be helpful, who you could see was trying to be truthful, who over 45 minutes, because transfer meetings are always held, and he had had transfer meetings with the same two people on other files, his mind filled in the gaps, and all of a sudden there was a transfer meeting on this file. A confabulation was formed in 45 minutes in an adult where no one was trying to manipulate him. It was the most fascinating thing to see memory science play out in real time right in front of you. So the idea of false memory is not just theoretical. We don't just read about it in textbooks. It happens. It happens every single day. And it happens a lot in high conflict family law because people are motivated to manipulate the children and to make direct false allegations themselves against the other parent. We, of course, once you prove the negative and you prove that it didn't happen, and I'm going to shortly show you some tools for that, the law can and does throw the book at the people who would make that sort of false allegation, but sometimes not. I have a list, like a bibliography from my library, of all the memory law, memory science books that I have. If anybody's interested, I'm happy to share it, but let me share screen just briefly. Peer-reviewed journal article from the journal Memory, directly on point from 2015. So 7 years after the British Psychological Society publication that I was showing you. And here you are. There's a lot out there. If you look for it, I have textbooks and textbooks, as well as peer-reviewed journal articles, such as this one, that people should know. Lawyers should know. Judges really ought to know, but usually don't. custody evaluators should know. I think we need to do a much better job in continuing education for professionals about this. So I've started really to talk this up. I spoke about this to some extent in Fort Collins. I spoke about this to a group of therapists in Pennsylvania. I recently spoke to the Bay Area, San Francisco Bay Area Psychological Association, in part about this. It was a much broader talk. And I think we need, in circles where people are dealing with false allegations, to talk this up. Because we always face the chestnut of, oh, that's the way trauma works, so the biggest argument we have, like, why is this only coming up now, and in a way that it has such an effect on the parent-child relationship, but apparently didn't at the time. It's just not logical, and yet far too many people say, oh, it was hidden by the trauma. And then you look at what was actually going on at the time. There was no trauma. The children weren't acting traumatized. It's just revisionist history founded on this falsity that memories just get buried. That falsity was behind one of the worst episodes in North American therapeutic history. There was a period of time in the 70s and 80s where many therapists were a standard course suggesting to their parents that to their patients rather, that their problems must be deep rooted in some sexual abuse that they must have suffered. Some weird twist on Freudian psychoanalysis. And many people, both the patients themselves as well as the family members, really got hurt by that era till it was completely debunked. And one of the leading practitioners involved in turning the study of memory into an important science was Elizabeth Loftus, Loftus, who authored The Myth of Repressed Memory, Witness for the Defense, many other books and scientific papers, and was behind the forming of the False Memory Foundation. I've already mentioned Dr. Julia Shaw's much more recent, very accessible book called The Memory Illusion from 2016. So this process destroys lives, destroys families, destroys the very children who were supposedly protecting from manipulation. So what I want to do just very briefly, and I'll share screen again, is show you some of the difficulties that we're actually having in the legal field. We have that beautiful publication that I just showed you from the British Psychological Society, Recommendations on Memory in the Law. Not a very well-known publication, but it should be. So what does our law, the Canadian law, tell us about trying to introduce some of the science that I showed you into court, you guys are seeing a legal brief that I put together. And here's simply stated the problem that we have as lawyers trying to deal with this. The high-end understanding of children's suggestibility, how false memories form, and things of that sort is an area of scientific study, is not well known to judges, and therefore, assuming you have a properly qualified expert, someone who's independent and whose expertise is widely recognized, and hopefully they've all previously testified as an expert in cases. But actually, a lot of cases are saying, no, we're not going to allow the admission of that expert report because it's intruding on what judges do, assess credibility. We judges know that memory is frail. We judges know that people can get manipulated and false allegations can be made that are adopted by the children. I don't need, therefore, an expert telling me that that can happen. So you go through and you hire an expert who does a report, and it's either a non-case specific report or it might also add some case specific examples of why the children's statements in this particular case are not reliable, what aspect of our understanding of how memory works is offended by the progression of the statements. But then the judge says, I'm sorry, it doesn't pass the Mohan test in Canada. That was a Supreme Court of Canada case, which is the same thing basically as the Daubert and Fry standards that expert evidence has to pass in the United States. Is it really necessary? Does it intrude on a judicial function? Is it reliable? Etc. So, interestingly, when you go through, and just to show you what this looks like, so if you look at paragraph 1 here, expert evidence regarding the fallible nature of memory is not necessary for the trier of fact and therefore inadmissible. But do judges really understand beyond this general thought that memory could be fallible? Well, we all know that. Even lay people know that. But what about the specifics of how it's fallible, and that recovered memories are exceedingly rare? And when we recover a memory, it's not with a lot of details. It's just with much more vaguer recollections. That cannot be within the knowledge of the typical judge. And so going through this memo, you'll see here in paragraph 3, I'll see if I can highlight it. Hopefully the highlighting shows on your end. There's a reference here to Dr. Timothy Moore. Well, in this memo, there are cases where Dr. Moore, well-known scientist in this area, his evidence was accepted. And there's a lot of other cases where his evidence is not accepted, not that because there's anything wrong with what he's saying, but because of the principle in point 1. Judges are expected to know this, and since judges are expected to know this, you shouldn't have an expert putting expert information into court. So the case law is all over the place, which it shouldn't be, because this really is more complex than a simple statement like we do this all the time would tend to suggest. So let me scroll down to some of the cases where Dr. Moore and others' evidence was accepted. So here, look at paragraph 13. Paragraph 12 and 13 are examples of cases where the same professional talking about the same sorts of things was accepted by the court. Because they're speaking to the science in a much more detailed, granular sense than simply memory can be fallible. And in particular, what are the differences between a child's ability to recall years later after being subjected to all kinds of wrongful influences versus an adult's? It's hard to hold the view that all judges really understand that. So there's a struggle going on in terms of educating courts. And if the courts are going to say, no, this is a core competency of judging, then arguably there should be a lot of judicial continuing education on the very memory science that some judges are saying, sorry, it doesn't pass Canada, so sorry, it doesn't pass the Mohan test, and I'm not going to allow that expert to testify. It's troubling. We seem to be drifting in some middle ground, needing some guidance, and since a lot of the cases I was showing you are Court of Appeal level cases, this may be something that needs to go to the Supreme Court. Is memory science just something that judges take judicial notice of? If so, I'm the lawyer on one side. I know what sort of memory science I'm going to put in and say, well, you're supposed to know this, Your Honor. So I'm just going to put in the British Psychological Society publication. They're just a reminder, Your Honor, of what you're expected to know. The other lawyer is going to say, you can't do that. That in and of itself is opinion evidence. You can't put that before the court. So where does that leave us? It's quite unsettled. So let's leave then memory science. Hopefully everybody's learned something. And I would urge you all to find, I'm happy to email it to people, the British Psychological Association publication, and do some research yourself on memory science and how it might apply to your case. And if anybody's really interested in following up with the discussion about that, and in particular, I'd love to hear from some US lawyers about this. Be very happy to hear from people. So, attacking the validity of memory is one tool we're going to do in a PA case. But there's a broader spectrum of strategies and tactics to prove a negative that I've developed over time. So, with that being said, I'm going to share screen again and take you through part of the slide deck that I used in Fort Collins and show you some of the forensic tools, tools of argument, tools of critical thinking that I've developed over the years. And if, just as a total aside, because it's not the focus of this evening's presentation, if you're dealing with a service provider, whether or not they're going to be an expert in the case, a therapist, a parental coordinator, a custody evaluator, they may, in addition to falling prey to errors of not understanding memory science, be subject in their logical reasoning, as are judges from time to time, in terms of cognitive reasoning errors, what we call cognitive biases. And for those of you who want to understand more about that, look up the following. The Cognitive Bias Codex, CODEX. Just look that up, and you'll see a graphical depiction of 188 different types of biases. Errors in critical thinking, if you will. And there's a related Wikipedia description that does a very good job there. And then, of course, if you want to go further, there's all kinds of textbooks on that topic that might help. There might be some pearls of wisdom there that would explain why what to you are obvious falsehoods are not resonating with everybody else involved, that they're obvious falsehoods. And it may be because certain cognitive biases are at play. Could be errors of not understanding memory science, could be errors of not understanding biases in clinical reasoning. But now I'm going to show you a bit of a forensic, if you will. What are some of the tools we can deploy in trying to do the proverbial? How do you prove a negative? And proving a negative is a difficult challenge. And even after you prove the negative, there's still an ongoing stink or concern relating to a parent who was accused, even though it was dropped, but accused of some sort of vicious, disgusting abuse. There's a stench that sometimes just doesn't go away. There's a lingering taint in how everybody is going to think about the case. And some judges have even reflected on that when they're assessing significant damages against somebody who levies false allegations. False allegations are not a victimless crime. They distort children's critical thinking skills, and they leave marks, they leave wounds. How do you prove a negative? I guess can't really expand the screen much more than that. Okay, so in the typical case, those of you certainly of my age will be familiar with the arcade game Whack-A-Mole. And those of you who have participated in therapeutic work meant to restore your relationship with the children or your client's relationship with the children will be familiar with the layered approach of false allegations. And again, I'll pull an example from a recent case of mine. Long-standing equal parenting. Just about the entirety of the child's life. But the offending parent always like a circling shark looking for an opening to jump in and destroy the relationship. And usually timed in and around points of major decision making in the child's life, what elementary school, what doctor, what high school. So I have to stir the pot, interfere with the relationship with the other parent and the child so that I get to singularly make those decisions. And of course, I want to collect child support that I'm not getting. While it's equal parenting, there's another incentive. So this comes to pass, and the child is just wiped out of the father's life in blatant breach of the prevailing court orders. And he's begging and pleading for time. And it's like, child will only see you with his best friend and his best friend's family. That's it. He's not coming to your house. He's not going anywhere with you. And basically, you have to coordinate when that other family is available because that's the only forum. And with the only, quote, supervisor, child is prepared to see you. Completely bogus. Takes a long time to get into a therapeutic process. And then a long time in that process till we finally get father and child in the same room. So I'll digress for 1 second to remind everybody that in the history of therapy for children, a relational problem, parent and child, has never been cured in individual therapy with the child not involving the parent that allegedly the issue exists with. For many, many reasons. If it's a relational issue, an individual therapist should say, whoa, hold on there, Johnny. Happy to talk to you about issues at school, issues with your peers, feelings. But the minute you start raising problems with your mom, this isn't the forum. You need a family therapist. You need to be discussing those issues with your mom in front of and with the assistance of the family therapist so that you guys can work it out. I can't deal with those issues in the course of my services. That's what an individual therapist should say. I think the vast majority of them don't say that. They make that error, and therefore they make the family system worse off. Just an aside. So, a family therapy process was put in place. I was acting. I know this. And after lots of meetings, just with mom, just with dad, just with the child, mom and dad together, well into the process, we finally get to a meeting of dad and child. So you would think with all that prep work, and there is evidence-based science that for a family therapeutic process to work properly, as frustrating as it is for the parent chomping at the bit to get back with their child, you do have to set the groundwork. Make sure, in the parlance, that all oars, think about the rowboat analogy, you need all oars pulling in the same direction, or else the rowboat just goes around in circles and you don't achieve anything. So you lay the groundwork, big build-up. Here we go, meeting of father and child. Now, no parent should ever be sandbagged. The therapist knows what the child is going to say. The favorite parent knows what the child's going to say. But as happened in this particular case, my client had no idea what the child was going to say. I haven't seen much of my child except with his friend and friend's family for the last year after a decade of equal shared parenting. what's the issue? So I'm going to draw again from the movies in honor of the Los Angeles base of ISNAF, even though I know you have members from all over the place. So this time I'm going to channel the first Jason Bourne movie. I think it was called The Bourne Identity, where the Paris station chief famously says to the Matt Damon character, I can't solve the problem, Jason, unless I know what it is. Why would you sandbag a parent? It would have been more helpful if at least the issue, which my client had been writing about for a year, and I'd been writing about for a year, why is the child not coming? What is the issue? And what we got back from the other side is, we don't quite know ourselves. Well, I'm pulling the BS cord on that one. Of course they knew. So, that being said, that's how not to do family therapy. You never sandbag a parent. You prep them. Here's what I think the child's issues are, to give you a chance to think about it in advance, etc. So, heading into this meeting, my client had some serious trepidation, as did I, waiting to hear from my client by phone. And he attends, at least he's in a room with his child, not with the child's friend and friend's family. That's a first in a very long time. Now, you would think, and it did happen, that what we're going to discuss in this meeting, time permitting, is the top 2 or 3 issues. Start with the most material ones. Great, that makes a lot of sense. Been waiting for a year. What are they? And interestingly, by the end of the hour of that meeting, all 3 issues were raised, discussed, and once a light was shown on the issue, and the father said, well, child A, I'm puzzled about that because of this and because of that. And you'd never said anything about that to me. And then it would dissipate. And the child would just accept that that's not a reason. Let's move on to number 2. The top 3 issues disappeared in 1 hour once you got child and parent together with someone whose job it was to heal, and the child was forced to, not hiding behind the alienating parent, but you're on the hot seat now, Johnny. No one's jumping on you. We're here to figure it out, to solve, to forgive, forget, craft a better future. Help us out. We want this to heal. And the top 3 issues have no staying power whatsoever. But I've left the slide up on your screen about the whack-a-mole machine. Because you would think that, wow, we got rid of the top 3 issues, things are going to start to move. Johnny's going to go for lunch with me alone next week. We're going to head back up that hill. But it was not to be, because Johnny goes home, talks to mom. Basically, we're totally exposed now. Like, I'm never going to be able to play that hand again. What else am I going to say? And mom and child A invent more. Then there's another session. and it's more of the same. Where did this one come from? You've never said anything about it. That never happened. And the same thing happens again. It dissipates. But the allegations keep coming in waves, and they don't hold water when subjected to scrutiny. So here's a less polite, if you will, quote from The Shawshank Redemption. After the prison warden discovers that Kevin Costner's character has somehow escaped, and nobody can see how, and he's angry at the guy who's head of all the prison guards and another prison guard, and he yells at them and said, "It's a conspiracy. The man up and disappeared like a fart in the wind." Well, that analogy applies very often to the reasons children are giving for not seeing a parent. It's ephemeral. There's absolutely no substance to it once you subject it to some sort of logical Sherlock Holmes-like peel the layer of the onion back calmly, questioning, oh, okay, you're saying that. I'm puzzled because of this. Or think of Columbo, if you're a fan of late night TV. Very much that sort of attitude. So on the succeeding slides here now, I'm going to show you some of the tools that I've developed over time. And I just want to see whether these slides are out of what. Okay, yeah, no, we're good. Okay. So use demonstrative evidence. Demonstrative evidence means charts, lists, graphical timelines, charts with arrows showing that while 10 people said mom screams and yells at children, she doesn't have good parenting skills, it all emanated from dad, because a teacher saying it. Well, did you ever witness that? No, I was told that by the child. The child protection authorities are saying that. Well, did you ever witness that? No, I was told that by the father, or I was told that by the teacher who had been told that by the father. And so you do a chart with all these arrows showing that at the end of the day, there's only one source. There's 10 people saying it, but it's all second or third hand. That's another example of demonstrative evidence. In the false allegations of sexual abuse trial that I just finished, I did charts over time, longitudinally. So I take a particular allegation and I would show when and how it first appeared. And they were kind of chronological. And what became of it? And does it conflict with assertions later on, or assertions as between the children? Or does something totally new show up in year 3 of this mess, but that relates all the way back 7 or 8 years prior, but nobody had said anything about it? So I had charts of the children's statements, and where's the statement from? Mom's affidavit, the children's lawyer's interviews, or the Child Protection Authority interviews, or some other source. I similarly had charts of the mother's allegations. over time. Where do we find it? Her therapist file that we got, her doctor's file that we got, an affidavit that she wrote. And then you show the evolution over time. She tried this, this, and this, but was still stuck with equal parenting. And then it went to a mini adjudication with an arbitrator, and she got stuck permanently and had to settle for equal parenting. And a children's lawyer interviewed the children, and they were cool with dad. So this wasn't good. She had to up her game. After those, things got worse. Allegations got extended. She had been, but she ramped up the grooming of the children. And you can see that when you show it graphically. So demonstrative evidence, charts, lists, etc. I did one trial where I actually have that father's concurrence that I can use all the trial materials when I do speaking engagements. And I've used it as a case study when I lectured in Ireland and in other places. What I did in that one was I took all the different allegations and I mapped it to the mother's sworn statements in the case. And what would happen was you would see certain allegations consistently made, and then they disappear, never to be asserted again. Or they disappear for 2 years, but then they pop back in the pre-trial process. So not very likely, or there's nothing, and then boom, there's something, but yet she's written 5 affidavits already in the case over the years with not a word about it. Not very likely. Or one of the allegations which featured prominently in that case, where a very serious allegation had no basis in reality, evolved over time. One child had been sleeping upstairs at dad's place. The other child was about to go upstairs to play or to check on the other child, and the father kind of grabbed that child at the arm just before that child was going upstairs to say, shh, other child's sleeping. And the child had just slightly stumbled a bit as a result of the father just saying, no, don't go upstairs. Well, the mother gets wind of this, and then her allegations in various forms and in sworn statements evolved from the father tripped the child down the stairs, and the child went all the way down the stairs and got injured. The father pushed the child down the stairs, to eventually the father threw the child down the stairs. So not only was there no downstairs, it was going upstairs, but the allegation evolved from tripped to pushed to threw. Very apparent when you do these charts, the use of demonstrative evidence. Let me talk about hypervigilance, this term down here. What do I mean by that? We know that if you're worried or scared about something, you're going to be hypervigilant. And sometimes that's not good in relationships. You're going to misconstrue things, or you're going to have a hair trigger if you feel insulted. You're hypervigilant. Children who've been programmed against a parent are hypervigilant for anything that parent says, they're going to be searching for a negative connotation. But there's a different type of hypervigilance that can sometimes be useful in a defensive way for a parent who's being alienated. And it goes like this. Shortly after separation, after years of being a model citizen, you're accused of physical or sexual abuse with the children. It's investigated and dismissed. You are going to be hyper-vigilant from then on. You're going to put cameras in your house. You're going to have friends and family members around all the time. You're going to be very careful to ask your children for permission to hug them. How sick is that? You're going to be hyper-vigilant because of the history of false allegations. So what that means, you were a safe parent before. Now, you are the safest parent, the safest person on the planet to look out and care for these kids, because you're under the world's biggest magnifying glass and you know it. You're going to be hyper-vigilant. We should not be concerned because of the previous false allegation that got refuted after it was investigated. Because if you weren't safe before, you're certainly safe now, because you're not going to risk anything to expose yourself ever again. Okay. That's hypervigilance. It's an important thing. Now, normative parenting. If you don't just wing it, mom parented, dad parented, my friends' parents growing up, I saw their parenting, and so I know how to parent. Or it's intuitive. No, there is a science to parenting. Read, learn, do courses, have a parenting coach. Put a protective cocoon around your parenting. But these slides here, how do you prove a -1? How do you prove a -2? Look at tool 8. Search for discontinuities. There's another point. Search for absurdities. The more absurd or logically inconsistent, which is kind of tool 8, when you can show that you've been subjected to 15 different allegations and you can dismiss 10 out of the box as either being totally absurd, it just has nothing to do with how the kids behave toward you, don't even really understand it, and others just logically inconsistent for various reasons in your case. Remember not to say, phew, that's great. Now let's just focus on the remaining 3 or 4. We can forget about those other ones. No. You keep a laser focus on the ones that you've disproven, because the fact that they were made in the first place is very telling, and you shouldn't let the other side off the hook for their lies and exaggerations. You keep reminding them that everything you say, the first place I start are the 10 raised absurd allegations. There's something wrong with you, or you're lying, or you're trying to manipulate, or even suggesting those in the first place. So again, there's 4 or 5 slides here. You see, 3 gets us up to tool 15. So let's just look at tool 14, the the base rate. There's a type of logical reasoning, statistically based, called Bayesian reasoning. You can look that up. Our colleague, the late Dr. Steve Miller, was a big fan of using Bayesian reasoning in reasoning under uncertainty, trying to figure out what's actually going on. A parent with no prior history of emotional dysregulation, was not a yeller before, never hit the children before, never sexually abused the children before, then getting separated, knowing that there's a lot of false allegations in family law cases, the base rate of physical or sexual abuse in families that is of such a level that children wash their hands of a parent is tiny. The base rate of parents doing that to their own children, not just any child, their own children, is even smaller. So what Tool 14 says is, we start with the clinical hypothesis that it is likely not true because it's got such a low base rate. We need to make sure that there's sufficient focus, not just on the targeted parent, but on the favored parent and the child. How could you possibly be saying this when the base rate in population-wide thinking is so low? Do you have some sort of smoking gun? Or are you going to say that the mother chose the time of separation to suddenly become, not just she went from excellent down to normal, down to one of the worst parents in history? I have one going on now where I have no doubt that the allegations are false, but if they were true, my client is a sociopath. And the story and the analysis using these tools that I've put together on her behalf strongly suggests to me that the allegations are bogus. But think about the base rate for, I'm going to change the profession to, out of respect and privacy, a pediatrician. Someone who's devoted themselves to helping children's medical needs. What's the base rate of pediatricians who would totally, physically, weakly, seriously, physically abuse their own child? What's that base rate? Not just your average parent, a very educated person who has chosen to devote their professional lives to assisting children. But at home, with their own child, they are allegedly a monster. That base rate must be almost zero. That's the thinking that we should start with in analyzing these sorts of cases. That's what Tool 14 is all about. So I've pretty well hit that mark where I'm going to stop the more formal presentation, remind everybody that what I've shown you on screen I'm going to make available to Cindy, and open it up for some questions.
Well, thank you, Brian. That was really insightfully amazing with a whole lot of information in one presentation. So thank you. Okay, I don't know if you read through the long questions and there were.
I did read through the long question, so let me start with that. It was a question about the use of recordings in a conflictual family law case, and in particular from California, which is a dual consent state, apparently, meaning that it's illegal to record a conversation that you're a part of unless the other participants in the conversation have been told, by the way, I'm recording this. There are other states, and certainly in Canada, our federal criminal code, the matter of federal law in Canada, states that as long as the person recording is party to the conversation, they can record. What you obviously can't record is private phone calls between the child and the other parent, even if you suspect that there's some child abuse going on in that call, with the child being poisoned and manipulated. But that being said, and this is kind of one of the questions that's being raised, does anybody ever prosecute anybody for recording in these circumstances in a protective sense where there's a child protection concern because you have evidence to show that your child is being alienated from you? I'm not aware of any prosecutions. And is it admissible? Because you'd say, how do you get illegally obtained evidence into a court? Well, interestingly, getting any recording in a family law case admitted into court is a fairly high hurdle because the courts really look down on that. They do not want parents recording each other in these cases, but they'll always listen to the recording to decide whether it is meaningful enough that it has to be admitted, because PA is, happens very subtly, very mischievously, behind the scenes, not meant to be seen. And sometimes these recordings just make the dynamic clear. So, and sometimes parents are recording because they've been accused of all kinds of stuff, and it's the only protection they have. So I guess the bottom line is, where child protection and emotional and psychological safety is one of them, is at play, you can often get meaningful recordings, like smoking gun sort of recordings, into court, even if illegally obtained, because the number one paradigm is the protection of children from harm, and it's often very hard to prove what's going on. You've probably had other speakers who have made the point that PA is counterintuitive in nature. It is. So that's really the game on recordings. I have statements of law that I use when I'm trying to get recordings in, and I have statements of law that I use when I'm trying to keep recordings out. You have to be flexible that way, but I've described what the paradigm is.
So Brian, I'm going to be that client. Well, I wasn't your client, who got in a lot of trouble with recordings in the state of California. So I did record conversation between the stepmother and my child, and there was very disturbing information. Careful what you want to hear, because then now I knew I have a problem, and how am I going to address this? And now it was so severe I could not let it sit. So I did have it transcribed. I took it to the reunification therapist, played it for him, gave him the transcript to read, and then left with all of it because I had been coached prior. And I'm being told, you shall not disclose this. Are you kidding? You're going to get in a lot of trouble. But I knew I needed to help my children. And that did end up in court. On an ex parte, they found, because therapists needed to speak with dad and stepmother to verify that the conversation had actually occurred. And I told him, they're not your clients. I forbid you from talking to them. But everybody was just violating everything everywhere on my rights. So it ended up in court. They took it on ex parte, and the judge actually took custody from me that day of my son. And they threatened to sue me in criminal court for illegally recording. And the judge forbid them from doing that and said if they took that action, that would be more harmful to my son, and he would remove my son. So instead of suing me in criminal court, they sued me in civil court. And so I was able to get that dismissed eventually. But then the narrative became, in my case, you stooped as low as doing illegal recordings. And so that's who you are as a parent. And that was the narrative to put my nail in my coffin.
Okay, so with Cindy's experience in mind, here's often what we will advise clients. If your child is disclosing all kinds of funky stuff that's going on at the other house when they're with you, have guests, have visitors, have family members. If 2 or 3 people at the same time hear the child say, it's very disturbing, I get sick to my stomach, Mom, everybody's talking bad about you at Dad's house, and 3 people hear that from the child and say, that's horrible. What do you do? What do you say? Can you leave the room? What can we do to help? And then they all give affidavits as to that. It's pretty well as good as a recording. So that's one tool. The other tool is to record, but keep the recording to yourself. Not meant to be used. It's meant to be there solely if the other side actually puts something in a sworn affidavit that conflicts with the recording. I used that recently in a long-standing alienation case where the alienating mother made all kinds of assertions to that she was complying with the requirements for parent-child contact and what she had seen and stuff. It was just a total pack of lies. And the father had a video record of what was actually going on, which, so we waited until she put it in an affidavit. He then replied, no, what I put in mine is true. Hers is absolutely untrue. And I have recordings of every single visit. I'm happy to make them available to the court if the court wishes. But here in my reply affidavit, I'm saying Mom is a total, utter liar. And I stand behind what I said in my first affidavit, and I can back it up. We never had to produce the recordings. Everybody just accepted that what this father had said was happening on the visits was true. So that's also another way. Don't use them unless and until you can make the assertions that that this is happening, that's happening, the child's being manipulated, you need it to stop. And then the other says, what are you talking about? I never talk like that. That never happens. And meanwhile, you're sitting like with an ace in the hand with the recordings. So you can state with confidence, I'm sorry, that's a lie. Yes, you did. And I can prove it. So sometimes recordings are worth more undisclosed than they are disclosed. So that's another way to play it.
Yeah. Well, and in coaching parents, what I've seen recently, because that happened back in 2010 in my case, what I've seen recently is there's a whole lot of Zoom, I'm going to say visitation time that goes on with children while they're with one parent with the other parent. Those appear to be recorded and the court welcomes those here in California. When there's a therapist and the child seeing a mental health professional, is there any responsibility they have regarding verifying memory for the child? And do they have any training on that? Because then they validate the false allegation.
Right. The sad part is they probably don't have training on memory science. I know when I've been speaking recently about it, everybody's finding, professionals are finding this very, very interesting. And I would have thought that this should be well known in the therapeutic and evaluative communities, but apparently not. So I would say yes. I mean, if you're going to deal in this sort of professional service, you have to know this. So hopefully we'll have started something here. We'll get more mental health professionals and lawyers and judges up to speed on current understanding in memory science.
I think with false allegations, that would be critical. Maybe you could do some presentations to some of these mental health professionals.
I'm always able and willing to speak to any group that will have me. So if people know groups of mental health practitioners who are helping families in the post-separation world, happy to speak.
Okay, so I'm going to just put this to our community. Those of you, clearly you're all interested in this because you're probably dealing with the courts and false allegations at some point. So I'm going to invite you all to see if you can invite your mental health professional to possibly attend a complimentary meeting, and we could have Brian present on that via Zoom on memories, and see if we could get a mental health community to join you, one that would be already supporting some of you. So if you can do that, please just send me an email and I will get Brian on the call. He's always so generous to commit. So let's see if we can create that. The word abusive is a sensitive word. When a person says, I was abused by him, most people will believe the person saying this without questioning it. This is what my ex has stated in her divorce papers. In Indonesia, where my children were taken, it's a long story. The alienations are completely false. She told the school, private Catholic, my daughters attend the same story. They will not talk to me or engage with me because I am deemed dangerous. Is there any language I can use to persuade them to agree to a meeting with me to debunk these allegations? How do I refute these false allegations?
Okay, well, first, a piece of rhetoric that I actually used in Fort Collins, got a bit of a laugh, is that the word abuse is the most abused word in the English language. It's vacuous. It can mean one thing to one person, one thing to another. People who are looking to justify a child's rejection of the parent will take the slightest fault, the most innocuous event, and suddenly state it's abusive, and that's what caused the complete rupture. Regardless of the allegation, every non-party, schools, doctors, sports coaches, you name it, should adopt innocent until proven guilty, particularly with serious allegations when using some of the tools in the slide deck, there's a discontinuity there. We didn't see the child, leaving aside what the child is now saying post-separation, the child's actions prior to, close to, immediately after separation are not consistent with the wild statements the child is now making. Innocent until proven guilty. So you should get a forum where you can attempt to ensure that service providers to your children are not misled, because it's going to interfere with the nature and quality of the service that they're providing.
That. All right, so we have our next question. This is from a parent new to the world of alienation, it appears. What can I do now to prevent false memories being implanted into my 6 and 8-year-olds from becoming a problem years from now? I'm just divorced and see the beginnings of PA. They are in individual therapy to help them process the divorce. We parent 50-50.
Make sure that the child is continually being exposed to positive experiences and the raw material, if you will, of positive memories when they're with you, and make sure it's broad. Make sure the extended family and your friends are seeing the children as well. Get the hook in deep. So the best defense, if you will, is a good offense. Now you'll face in future, I don't know, this must be written down somewhere, but you have all these alienating kids when they're shown the film and the pictures, having a great time with mom over the years, is, oh, she forced me to smile. They threatened that they would starve me unless I smiled. You hear the most bizarre. So that's when a child says that, you pull the BS cord. You just, like, sorry, but that one's just a whopper, and I've got a lot of difficulty. There are thousands of pictures and hundreds of videos spread over 8 years. So I just want to make sure I get this one correctly, little Johnny. Every single picture and every single video where you're smiling was because they threatened to starve you to death if you didn't. And most children, they're just not well trained. They can't see the setup question. And so they'll usually answer, because they don't understand where you're driving at. They'll say, yeah, every single one. And okay, thank you very much. And then you know the child's lying. So Cindy's right. Take lots of pictures, lots of videos with lots of different people. But of course, this is best done long before separation. Like, I wish it would be a real downer if every recently married or recently partnered couple had to come and spend an hour with me, and I prep them for what they must do over the years in case they become one of the 50% of couples that doesn't make it long term. You have to keep all your financial records off-site. You have to keep all your treasured memorabilia off-site, or copies and stuff, all your films and everything. You have to have an online backup of every file, photo, video, because your computer's likely going to go missing when you separate. You have to make sure that you and your family members have lots of touch points with the child, validated by doctors and this and that the relation, it's still good, still great today, still great today. So it's like you're building the anti-PA case while you're just enjoying life as an intact family. If you want to be bulletproof, then this is how you have to conduct yourself. Like, who would want to tell a recently married couple, by the way, let me in, by the way, do you know what the number one cause of divorce is? Marriage. You'd want to sit down with a couple to explain this to them. It's really difficult. The minute someone sees the wheels falling off the bus, particularly, these dynamics, these alienation dynamics will start many years prior to separation, the alignments in the family. That's when people should go and get their first advice. Don't wait until things are critical.
Yeah.
Look
So-
into these at the earliest possible signs.
Yeah, so something you said about smiling in pictures. There's a mom that I was working with who was representing herself here in California, and she has a 9-year-old child now. He was 8 at the time, which was like maybe 4 months ago. And part of her evidence that she presented to the court was that her son stopped smiling in photos and told her he wouldn't smile anymore. But she had pictures of him prior, and she was able. And I went to court with her. I observed the judge. I observed, and I saw her orders, and she got favorable orders and was able to show that the dad was influencing this 8-year-old child at the time. And that was one of the tools that she used. But it was to say he refuses to smile in pictures now. I'll show you the pictures. Here we go. Considering a new individual therapist for our 8-year-old son with his mom, the favored parent. The therapist said they won't question validity of memories and that they can resurface in the child because of trauma. Should I try to re-educate or run away? What's the best way to say I'm opposed to this therapist and looking for another? Lots of absurd allegations were unfounded, and although the court made no finding, it ruled there was no influence on the child and ordered family therapy for me and our son, which so far my ex is not allowing after 1.5 years.
All right. So I mentioned at some point that individual therapy is contraindicated in these cases. And in this particular parent's case, the individual therapist is committing 2 major errors. One, dealing with relational issues in an individual therapeutic process, big no-no. And 2, there's that statement again that allegations can arise years after the fact because trauma papers over and hides the allegation. It's a falsehood. It's not the way memory works. And so I think the biggest problem is that the therapist is acting outside their boundaries here. And you may have to look into a licensing board complaint because an individual therapist should not be dealing with relational issues and should not be taking, particularly in a separated family, just everything the child says must be true is just a major clinical error.
So that's a good point. So now that you've clarified that for us, once you file that allegation, that's going to get them off the case anyway, correct? Once you file that complaint.
Quite possibly. Quite possibly.
How does that favor you, though, in the eyes of the court if you're filing such a complaint?
You have to be able to back it up that you weren't just doing it to get them off the case. Like it has to be very carefully crafted, and you would only file that complaint after giving them an opportunity to amend what they're doing. Stop accepting everything this child says at face value, particularly when it relates to me or his relationship with me, which is not even the focus of your therapy. So I'm giving you an opportunity, and here's this, and here's that, and here's a professional opinion, and here's some clinical guidance. Please pull it back. Deal with non-relational issues, and don't accept what this child says about me. You haven't even met me. You haven't ever watched this child with me, and it's not even the focus of your process. And if they don't, after you have brought that to their attention, legitimate, evidence-based, regulatorily backed concerns, and they continue. So I had I've had several with psychologists who crossed the line, who even said to the children, I don't think you should have to see parent A if they make you that upset, in the face of a court order, and on a relational issue, who got in a fair amount of trouble as a result. I assisted a client in British Columbia where there was an eating disorder specialist who somehow got involved and was determined to keep this boy from his mother. And it took years to finally get her off the case, and that only happened as a result of the trial. So there's a lot of incompetent practitioners out there.
Thank you for that. Now, Brian, I'm going to ask the last question. I'm sorry, we're at our time, so we're going to be ending our call, but we could go on and on and on. And there's several other questions. But with what you just said, is there anything you could send me regarding the responsibilities of the type of therapist? Because what you just stated goes on all the time, and they become the professional who will be the nail in our coffin on the false allegations. The child says, and it's validated, and I'm concerned about their trauma, and they should not be talking to the dad, and that's happening in individual therapy all the time.
Correct. So I would state two easy sources right off the top of my head. There's a 2003 article that was published in the Family Court Review. I use it all the time, still very current, by Jonathan Gould and Lynn Greenberg, titled, "Is the Child's Therapist Part of the Problem?" And that's 2003 Family Court Review, easily accessible on the internet, but again, I'll send it to you, Cindy. And then the other source to constrain this sort of harmful intervention in a family that's otherwise struggling anyway is the dual rule prohibition in almost all, doesn't matter what the discipline is, almost all professional standards and professional regulations prohibit dual roles. You can't be a child's individual therapist or a parent's individual therapist and also a family therapist, like starting to delve into relational issues. The rules conflict. And you'll see that in the professional standards. So just right off the top of my head, that's where I would go. But there's also a more broad-based failure of clinical reasoning. You're not even supposed to necessarily accept what your own adult client tells you, because they may be struggling to understand their existence anyway. You can't help them if you just accept at face value everything they tell you. You're supposed to be probing a bit. But in separated family dynamics, it just, if you have any exposure at all to the amount of lying that goes on, lying and manipulation in separated family dynamics, you see it, and therefore it's negligent. It's just professionally negligent, judged by scientific standards of the community, to just blindly accept everything a child in a conflictual situation is telling you.
So then let me ask you the next question and we're done. Okay. I know it's already 7:00. So when judges do allow that, they allow therapists to take dual roles. They're going to be the individual therapist for the child. Now they're going to be the reunification therapist for the targeted parent and the child. And they start with the negative narrative and believe all the narratives there. They never even included anything from the targeted parent, even when they made efforts to connect with the child. So could that be an appeals case if a judge does that?
Theoretically, if that ultimately skews the result, but the professionals themselves can nip that one in the bud. So the attorneys should know this, should point that out. Even after a judge might make that error, it's still correctable by a motion for reconsideration, by consulting with the applicable mental health discipline regulator, getting a statement and sending that around to everybody saying, I know that Justice so-and-so allowed this, but it's not allowed. So it doesn't really matter what Judge so-and-so said. The regulator of the activity says no. So you don't just roll over and let it happen. Firstly, you should be able to head it off at the pass because the attorneys are supposed to know this and jump all over it. But if the mistake is made, you get a letter from the regulator saying not allowed, not advisable. You get a report from some other experts saying this is not done, and then you bring it back to court to get it corrected.
Okay, well, thank you for sharing that, because I'm going to tell you that happens a lot. So it gets by, the professional is willing to do it, the attorneys let it slide, and the judge orders it, then says, okay, that's what we're going to do. So the regulator, where do we get a hold of the regulator?
Depends what it is. If it's like, again, I'll give you the nomenclature for Ontario, Canada. We have a college of psychologists that regulates psychologists. We have a college of physicians and surgeons that regulates psychiatrists. We have a college of psychotherapy that regulates psychotherapists. So whoever the particular licensing body is will have professional standards, but will also have a practice management consult line where you can run this by them, explain the problem, explain the dynamic in the family, and they will get back to you and say whether they think the dual role prohibition applies or not.
Okay, well, thank you. You gave a lot of excellent tools. I've been around for a really long time, and some of that happened in my own case. I'm like, great to hear that now because I can help other parents. So thank you, Brian. I'm sorry we're not going to have time for more questions. We've already gone over for just 10 minutes. But I do want to thank you once again, Brian. You're always, always welcome back. Look, everybody loves to have you back. And we invite you all to be in connection with Brian if you need any of his consultation. He's amazing. He does not work as a lawyer in the United States. However, he's a fabulous, fabulous strategist and can actually communicate with your lawyer and get them in alignment and give them guidance. And I've worked with him on several cases myself as the parent coach on that. So with that, I'm going to give one closing quote. I want to say thank you 1,000 times. And I know you and I are always in touch, so we'll be talking soon. And once I get the information from Brian, you don't need to reach out to me. I will just automatically send it to everybody who RSVP'd to be on this call. So this is my closing quote, and I think it's perfect for our presentation tonight. When I look back on my life, I see pain, mistakes, heartache. When I look in the mirror, I see strength, learned lessons, and pride in myself. So every day, as you're educating yourself, keep moving forward. Okay. Every journey and every challenge we've had is the lesson to be learned. And look how much I just learned tonight. So thank you, Brian. Thank you all for joining us. And we'll see you at our next program. And this is not goodbye. It's until we meet again.